Welcome back. You're watching HFO-TV, co-sponsored by AMF Capital, the Janik Law Firm, the Butler Exchange Group, and the construction firm J.R. Johnson.
Hi, I'm Greg Frick, partner with HFO Investment Real Estate. Here again with two partners from Janik, Ciaran, Connelly, and Chris Walters. We're going to talk a little bit for some strategies for landlords regarding some of these legal challenges with what's going on in the moratoriums. We had a previous interview and video. It's kind of laying out the groundwork and where we are. Again, we're filming this end of April, so again, things could change. And as we've said before, in what's going on in the world today on some of this landlord-tenant law, we highly advise, if you don't have legal advice or don't have an attorney, get legal advice before you move forward. And again, I want to thank both of you guys for taking the time out again to do this. It's very appreciative, and I hope both your families are doing well and you guys are surviving these crazy times that we're in.
Thanks, Greg. Yeah, just to echo that, we're here for informational purposes today. We'd be happy to talk with somebody if they want to give us a call if they need legal advice.
Perfect, and we've got the information there on the bottom of the screen where they can get a hold of you. So so again, in the last time we talked a little bit about the state order, the county order, the city orders regarding tenancies and the moratorium on evictions. What are some of the strategies property owners should be considering to address these moratoriums? Again, we're specifically talking about on the residential side. If we got time, we can maybe get a little bit in on the commercial for people that have some mixed use. But for our audience, predominantly apartment owners, maybe you guys can give a little overview on some steps there.
Sure. I think we've got maybe a few different categories we'd like to talk about. And I'll sort of give you an overview, and then we can dive right in. First is we want to talk about the strategies that you can use for downstream relief, how to continue to get paid by your tenants and make sure that you're not fouling things up in any way along that road. Okay. The second one is to look for upstream relief from your lenders and other folks that you might owe money to. And related to that, a sort of third category, trying to look for contractual relief. Maybe you have servicing contracts or other kinds of contracts that are being impaired in some way by the whole pandemic crisis, and there may be relief for you to pursue there. We're going to follow that up, I think, with some practical advice about things you can be doing today to try to make sure you're in the best position possible. And then finally, we want to talk about the prospect for some long-term legal relief in challenging whether some of these moratoriums are even legal in the first place. But we'll get to that at the end. So that's kind of the overview.
Okay. So where we are today, as we mentioned before, we'll do a quick. We had the governor's moratorium. We had Multnomah County and the city of Portland all having moratorium rulings on this, and the Chief Justice of the state as well in regards to doing the court process for evictions. What is some of the kind of downstream relief, being downstream with the property owner in dealing with the tenants might pursue to address some of the concerns or things that may happen in this situation that we're in?
Sure. There's a few different things. One, as folks may have heard, none of these moratoriums relieve tenants of their obligation to pay rent, at least not in Oregon. Rent is still owing. The only thing that's been abrogated by these are late fees during the pandemic and interest during the moratorium. But these moratoriums do allow tenants to delay payment until after the end of the moratorium outside of Multnomah County and Portland, or if you're inside Multnomah County and Portland, until 6 months after the end of the moratorium. So that they're still obligated to pay rent, but they can delay it.
So there is some confusion out there based on what's been, in the press, that again, it's not rent forgiveness. It's just a moratorium on, in essence, paying the rent, but it's not rent forgiveness. I think that's, we've had some feedback from some clients where they've had tenants. I think there was some confusion based on, where they've got their information or what they heard. So to be clear, it's not rent forgiveness.
It isn't. There's been some discussion with some of the governing agencies about imposing a rent holiday, but it has not been enacted.
And as again, we're filming this at the end of April. As of right now, that's where we are, where there's not a rent forgiveness. So thank you for clearing that up.
Yep. The second thing is that under the governor's order, tenants are obligated to pay what they reasonably can. And there's not a clear-cut standard for that, but tenants are supposed to be paying what they can now. So to the extent that's, if you get a phone call or something, you can say, well, why don't you pay me something at least, because, and you're obligated to under the governor's order here. One thing to keep in mind in all of this is that Multnomah County grace period or deferment that we talked about, that's 6 months. So that's going to be a factor in negotiating anything with your tenants. But there is this sort of one strategy that you might undertake, given all of this as backdrop, is that you might negotiate some amount of forgiveness with your tenants in exchange for them making greater than otherwise partial payments. You may want to have the cash flow to make make sure you're able to meet your obligations, and it may be worth something to you in terms of forgiveness to do that. But that's one strategy that you might pursue is entering into a side agreement with your tenants. But there's some risks that with accepting partial payments, and I think Chris is going to talk about those.
Yeah, so there's an overlay here. These executive orders and county ordinances can't change Oregon law. And Oregon law has a very detailed Landlord-Tenant Act in ORS 90 that discusses what happens as a condition to landlords exercising rights. And a very important section, which is, here we go, ORS 90.417, the duty of a tenant to pay rent, states the landlord may accept a partial payment of rent. The acceptance of a partial payment of rent in a manner consistent with Section 4 of this does not waive the landlord's right to terminate for the unpaid rent. Oh, what does Section 4 say? Section 4 says that you only reserve your rights regarding the unpaid portion of the rent if you enter into a payment plan with the tenant. Therefore, you have the overlay that streams like this. You get a letter from the tenant saying, hey, I read this executive order online. It says I'm only supposed to pay what I can afford. I can afford half rent this month. Here you go. If you cash that check, you may have fallen into the trap of ORS 90.417. And your response ought to be, if you want to reserve rights, okay, I can only accept this check if we reach some kind of an accord on a payment plan. Explain to the tenant that the very same executive order says that payment of rent is not excused, and sign up some sort of a payment plan. Maybe even if you're in Multnomah County, a plan to pay it 6 months after the moratorium. As long as you get the written payment plan, you don't fall into the trap of ORS 90.417 for acceptance of partial payment. It's not stated anywhere in these executive orders, but it's definitely something to be aware of as you get some significant percentage over time of your tenants trying to make partial payments. I suggest that Section 3 of this executive order will cause partial payments. It's a directive on tenants. Pay only what you can afford if you can't afford it. It's not tied to any particular standard. All the tenant must do is send a notice to the landlord to that effect, and the executive order says you're good. What the executive order doesn't clear, because of some ambiguity between sections 2 and 3, in my view, is clearly state that that unpaid portion that the tenant pays under Section 3 will be due. So my suggestion to landlord is, if you get a partial payment, hold on to, unless you're okay cashing that partial payment and waiving rights to terminate later, as the moratorium is lifted for that partial payment.
Got it.
Tell the tenant, send the tenant a notice. I'm letting you know the full rent is due. And for us to move forward, we need to come up with some kind of a payment plan. Call them, contact them, develop a written payment plan. Not only will you have inform your tenant and work with the tenant to come up with a plan the tenant thinks they can use to pay the rest, and inform the tenant that they do owe the rest, but you will also preserve your rights under the Landlord-Tenant Act.
By having that signed payment plan agreement, but yeah. Which brings up a question. I know some property owners that went proactively to their tenants and said, instead of paying, this much a month, I'm going to give you a discount of, say, $200 or $100 a month. What's the risk, long term, and is there a risk in long term of doing that? What's your thought on that, as opposed to taking a partial payment and making a payment plan, so to speak?
Are they asking the tenant to countersign that document?
I think some have. That's a good question. I think some have and some have not, and that's that. The question did come up about what happens if something extends out and I've given this tenant a discount on their rent, so to speak, not with the expectation I'm going to get paid back, but then do I fall under the guidance of 608 when their lease expires, and then am I capped at my 10% or whatever it may be? So
here's the risk under the statute that we were just talking about. Section 4 requires that the landlord accepts partial payment based on the tenant's agreement to pay the balance by a time certain. So if you have just unilaterally sent something to the tenant saying, here, we'll accept these partial payments, and the tenant hasn't agreed to it, you're at risk of not enjoying that exception to the waiver of termination and eviction rights for not paying the full amount due. So there's a risk to that. I suppose you could argue in front of an eviction judge, the tenant agreed to it by making these partial payments. But having the tenant's signature on something is much better given the language in the statute that says based on the tenant's agreement to pay the balance. By the way, this prohibition we're talking about is on eviction actions. You still retain your right to collect the rest of that rent in a rent action if you think that's productive. However,
Gotcha.
In my experience, most landlords use eviction actions as their main enforcement tool in these kind of cases.
And in terms of that, again, if the tenant on some of these needs to, pay what they can, so to speak, is there anything in regard to if I give this tenant, this tenant comes here, am I obligated to give it to, the neighboring tenants? The same? Or is it,
there's nothing in these provisions requiring you to do that. You still want to be careful of ADA provisions and making sure you're complying with HUD regulations and other things that way. You don't want to have different treatment of folks and expose yourself to liability that way.
So if somebody's going to give rent relief, that's kind of been a question with some of the property owners. They've said, well, maybe if I give a little bit of limited, give rent relief as opposed to doing like a payment plan, then the question became, did I lose anything down the road? If you give rent relief, you're not going to be able to, you're not expecting that difference anymore down the road, but it's I guess a decision on how they want to handle running their property. So
nothing in these ordinances prohibits disparate treatment of different tenants. And in fact, the paragraph 3 that we've been talking about is an obligation on the tenant.
Got it.
And thereby, because each tenant's in different circumstances, you apply that section 3 to each individual tenant and their individual financial circumstances and ability to pay.
So then we also talked about, Chris had mentioned about kind of some upstream relief, looking from a property owner upstream as to some relief. Maybe talk about kind of what you guys are experiencing in that and maybe what some of the options are. I mean, I would say 80% of the properties in the multifamily world have some kind of debt, mortgage tied to them or security tied to them. What kind of things should property owners be considering in this, the time that we're in now?
Well, in my view, the gating issue for a borrower under a real estate loan is, what do you tell the lender? And so first go to your loan documents and see what your reporting requirements are when you're facing a rent shortfall, whether you need your lender's consent to be cutting any of these rent deals, whether they're deferral or a reduction.
Right.
And finally, whether the rent reduction you're experiencing breaches a non-financial covenant of your lease, such as a debt service coverage ratio obligation or a cash call obligation, something like that. And this is going to vary greatly among loans. However, you generally see it in 2 or 3 different buckets. You have portfolio loans that are held by your bank. You may be in a very good position. You've got a quote classic friendly banker. You may be in a good position to get in front of it, talk to your banker, once you've got the data and you've experienced, you will have already experienced your April shortfall, if any, and word is it hasn't been that bad. May, I would expect more, and June, I would expect even more as the unemployment kicks in and as word gets around of paragraph 3 of the executive order. Keep in mind, the executive order was issued on April 1, the same day rent was due.
Right.
The order also plays, I'll tell you a funny story. The order also applies on the commercial side to commercial and retail leases. We got a notice styled after the governor's order saying, from a significant commercial tenant saying, we can't afford to pay rent. I was in the process of drafting a response letter when the client called and said, we just got rent. So I suspect in that case, the lawyer sent the letter on the same day that the accounting department cut the check. So in other words, there wasn't a lot of alignment on April 1. There should be more alignment on May 1 and 2.
Yeah, definitely on the commercial side for sure. I would imagine. I think a lot of the commercial ones, yeah.
To continue on the strategy side though, you've got your portfolio loans. You've got your loans that are backed by the federal government, and there are a host of agencies that have issued guidelines, not requirements, unfortunately, but guidelines allowing their loan servicers to work out payment plans and payment deals with their borrowers. And last, but very importantly not least, you have the commercial-backed loans, the pure private loans. And I think there's going to be maybe some structural issues there, at least perhaps without some federal relief, specifically because the person that you're dealing with is typically going to be the loan servicer. And that loan servicer may not have a lot of discretion to do loan modifications. The ultimate lender under those loans can be sprinkled out in 100 different tranches, and they may be shackled. Conversely, they may make more money on fees with your loan being in a default posture than being in a worked out posture. We saw all this during the 2008 recession, where sort of nonsensical responses were coming for lenders, and when you dug down, it all had to do with the servicing structure. So if you don't know, try to be cognizant and find out what kind of loan your project has been financed under.
Well, I know we've been talking to, in trying to educate a little bit with some of the people making politicians, that when they're talking about federal mortgage-backed relief, that's, Fannie, Freddie, HUD, but that's, probably 50%, maybe 60% of the multifamily existing loans. Single family is different. And so I think it was kind of enlightening. We had somebody, a lobbyist was talking, or somebody in the group was talking to, the city of Portland, and just saying, you can talk about, rent, people not paying rent, and there's going to be mortgage forgiveness, but you don't have the power to do, CMBS loans. You don't have the power for that. So, this is a little bit bigger of an issue and deeper. And, at the end of the day, some of that CMBS stuff is owned by your 401k and your, teachers union. And so it's not just as easy as, oh, hey, Fannie and Freddie are going to do some, mortgage forbearance for a little bit. It's more people involved. So I think, I'm hoping that as they dig into that, they enlighten that, we're all interconnected. And if we don't try to work on this thing together, you just can't keep, kind of kicking the can on one group to try to address it.
Speaking of kicking the can down the road, I think those of our investor friends should be looking at their package now and planning ahead. If you need to make a cash call from your investors, get ahead of it and let them know so it's not a surprise. Those were the workouts that were successful in my experience during the last recession, where the portfolio head, the limited partner, the trustee of the trust, whoever the owner of the property, who's controlling the owner of the property, is getting out ahead and making plans. You're much more likely to get investor buy-in if you've got a plan, rather than notifying your investors, hey, the bank just made $1 million cash call. What do we do?
Right.
So that's some of the advice for property owners in terms of exploring these strategies or kind of steps. Document what you're doing, planning ahead. Because again, like as we've talked about, on the commercial side, and we're talking retail, office, I think they almost feel as if they're 30, 60 days in front of where we were with multifamily based on what we saw for April collections. We'll see what happens next week with May and June and so on. And it was interesting. I think a lot of the owners that we know deal with, had conversations with their commercial tenants mid-March. Hey, there's things happening, and whereas on the multifamily, a lot of times there's not as in-depth conversations on that, and so it was kind of a wait and see. So again, in terms of an ownership group, is there any other advice you would give them in terms of laying out strategies or getting ready for again, they may not have to use this and things may come back, but what else would you guys say to a group out there listening?
Well, I think you definitely want to notify your tenants. If you get a shortfall or if you get a non-paying tenant and they're purporting to do so under the governor's order, tell them what the deal is. Tell them, thanks. We reserve our rights. They don't have to prove that they don't have financial ability to pay, but you can inquire into that. There's nothing that says you can't. And tell them the rent's due. They may be under the fair misimpression by reading the governor's order, because of the way it's written, that they only have to make partial payments. And I suspect it will at least start a dialogue with your tenant that at the end of the day may result in a payment plan that is beneficial to the property.
What about contract reviewing on the existing debt? I mean, is that something, again, where they would, reach out for legal advice, call your firm and say, let's review this? I think a lot of them, I hate to say this, a lot of times they're signing, mortgage documents and they're not reading, page 39, subsection, 17. I mean, where you guys could lend some advice in terms of experiences, what to look for, how that's going to affect strategy depending on the loan that's in place?
Well, sorry, Ciaran, go ahead and comment if you want. Absolutely, that's a lot of what we did in the last recession. And it's not just the loan documents, it's your investment documents, it's the representations that you may have made to investors, it's obligations you may have to vendors and how you're structuring that. Frankly, in some cases, it might entail bankruptcy discussions, but that's only probably going to be the case if this thing stretches out for a while.
Right. Yeah. Well, and just to amplify some of that, Chris, I think taking a look beyond just your lending documents to your vendor documents, whether they be folks that are supposed to be providing you with services, and that you get a letter from them that says, that under the current conditions, we can't provide that service anymore, but they still want you to pay them, or vice versa. You're going to have difficulty paying these couple of vendors. They're not really giving you the service that you want at the moment. There's any number of ways in which both the eviction moratorium and just the overall pandemic is affecting folks, their commercial relationships with each other. And how that all gets sorted out is highly dependent on your contracts and the circumstances of each one. And it's worth going through and reviewing those contracts, thinking about what makes sense for you that's going to put you in the best position going forward. And we can help folks with that, or they can review them with their attorney. But it's a good strategy to try to conserve cash, control costs, and otherwise make it through this time.
And what about back to the eviction moratoriums? Are there? I'm sure there is. I mean, we've had discussions. Legal avenues or challenging the legality of some of these. Is that is that in the works, or what's the firm's thought on that?
Yep. So I'm happy to talk about that. I think there are potential legal challenges to this. That we have both provisions in both the federal and the state constitution that prevent interference with contracts. We have takings clauses where the states can't regulate your rights completely away. And those the precise contours of a claim against the states or the county or against based on these moratoriums is going to be an intense thing. It's not a short-term relief. There's not a judge that you're going to find anywhere in the country that's going to give you a TRO saying, well, you can go ahead and evict some tenants because in terms of the big picture, you can always get compensated with cash later. Now, depending on how long this goes on and what the impact looks like, that may be a big amount of cash, and it may really be worth pursuing. So we're investigating that. We're putting together some theories, and we'll be looking for folks after this that have been significantly affected that want to try to pursue some of those things. So those are kind of the bigger picture, longer term things. But the thing to understand now is that that's not an immediate avenue for relief, but it is a potential one later on.
It's not going to address the short-term issue of, cash flow or, like I said, deferral of payment or something like that from your existing tenants.
That's right. But it doesn't mean that Chris and I don't have some suggestions for things that people can do now if they want to be in the best position, in a few months or half a year when some of this is finally shaking out.
Gotcha. Okay.
On the prospective litigation side, start documenting now. Start calculating your losses. Keep track of every dollar and get testimony from people, because now's the time to develop the evidence in your case as it's occurring, and keep those records. Ciaran, you can speak more about what I like to call creation of evidence. Look at your insurance policies now. Maybe you have coverage for some of this, rent interruption insurance, business interruption insurance. Don't lose track of any of that. Once again, this is part of the panoply of contract review rights. And of course, once again, the way these are enacted, this is supposed to be a deferral of rent from these tenants, not a loss of rent. And how likely is it in Multnomah County that you're going to see those 3 months of partial rent payments collectible in 6 months? I don't know, but it is something you can keep on your accounts as a prospective receivable.
Yep. Well, and just to go into that, sort of documenting your losses part of you, I think that's the major thing. So if there are, everything from terminations for no cause that you want to make, you wanted to terminate somebody's lease so that you could renovate their apartment, but you can't under the moratorium. Right. Document that, write it down, make sure it's got a date stamp somewhere, make sure that you note that the reason that you're not doing it is because of the moratorium, not because of, a lack of funds or you couldn't find a contractor or something else. But make sure that all of that is documented in a way that if you end up deciding later on that it makes sense to pursue a claim for it, whether under insurance or against the government or otherwise, you'll be in much much better position if you start documenting that now.
Yeah, it's much easier to pull things out.
Any action with respect to your lender or with respect to your tenants or with respect, as Ciaran is mentioning, a possible legal action against one of the authorities, make sure you know what your constraints are. Your loan documents may prohibit it. The governing laws behind your loan documents, if you have federal guarantees, may prohibit it, or your investment documents may require you to get consent or prohibit those actions without going back to your investors.
Great. Well, thank you for that update, guys. I think the long and short is in terms of either the long play of like we talked about the legality of all this, and even on the short term in dealing with your tenants. I think you just can't do it off the cuff. You need to plan ahead. You need to get advice, legal advice, to make sure. There's a lot of pitfalls for property owners in this. And, I think it's very important in these day and age now to, address that. Being prepared on the front end is going to save you a lot of time and energy and cost down the back end. Thank you, gentlemen, for taking the time to do this. I'm sure we'll do it, get together again, and wish you guys the best. And we'll, as we kind of go through these crazy times. So thank you again.
Much appreciated.
All right. And we'll see you again on HFO-TV. Be safe, everybody. Thank you.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.